again, everyone. I am Dr. Laurel Cook, Associate Professor of Marketing at West Virginia University. Welcome to the last digital marketing lecture of this semester. Chapter 17 covers social and regulatory issues, especially regarding privacy, security, and intellectual property. This chapter is particularly important, so you will have a grasp of the issues that make privacy, security, and IP so important to digital marketers today. Intuitively, privacy issues are likely to have come up in discussions about advertising and social networks. So are the security issues, both in the context of database marketing and of concern about identity fraud as a barrier to doing business online. However, intellectual property may not be top of mind for you as students, but you need to recognize it as an important issue for marketers going forward, especially as you consider a brand's digital assets. A question I have for you is, do we as U.S. citizens have a right to privacy? The answer may surprise you, because we as U.S. citizens do not, in fact, have a right to privacy. Indeed, there is no explicit reference to privacy as a right in our U.S. Constitution. However, as technology advances, so too does the U.S. Supreme Court. This court has held in several cases that there exists a right for us as U.S. citizens to privacy in the sense that we have at least a reasonable expectation of privacy, as implied in the First, Third, Fourth, Ninth, and 14th Amendments. The mantra online, however, not just in the U.S., but everywhere, is caveat emptor. Caveat emptor is Latin for let the buyer beware. In other words, this is the free speech and buyer beware rule of thumb online. However, many of us in marketing, especially in today's age, would suggest that internet users should actually be more protected. So my question for you is this: do you think that this buyer beware rule of thumb should still exist? This question is especially important as we consider that online users all around the world vary by age, by the degrees of tech savviness they have, their comfort with technology in other words, and consumer protection know-how. If I were to say that there's no way for sites to collect data without consumers being aware that data is actually being collected, would you say that this statement is true or false? Hopefully by now, you've built up enough skepticism to realize that this statement is probably false. And that's correct. As this meme suggests, there have been some social media providers, here's looking at you, Facebook, where consumers have been particularly burned by consumer privacy violations. These privacy violations have actually led to some pretty remarkable differences in how U.S. consumers feel about various institutions. This graphic, provided by Forbes, for example, shows how trust in institutions varies between the military, big and small business, all the way down to TV news and Congress. You can see where big and small business falls. The information highlighted here actually suggests some favorable implications for small business owners who have an online presence. Consumers' trust of small business online is nearly 3 times that for big business. Interestingly, there's a lot of information about online privacy as of this year. Most business professionals would say that data makes their existing business more profitable. However, and shockingly, only 9% feel that they're being very transparent with their customers about how they're using their data. As a result, it's only natural that consumer privacy concerns are increasing and becoming more severe. Most consumers are very concerned about not knowing how their personal data is collected and how that information is used. And they care about this information even more so than the thought of losing their primary source of income. Nearly half of consumers are actually more worried about privacy than they were a year ago. Many consumers have responded to these concerns by changing their online behavior. You can see that nearly 2/3 of consumers have limited their online activity, at least in comparison to this time last year, specifically due to this topic. A lot of consumers won't click on an ad, like a Google ad. They won't provide their personal information, even their email address. What I'd like you to know in this class, and something that's of particular importance to me as a social marketer and public policy researcher, is that there are vast differences in how online privacy is treated here in the US as opposed to other parts of the world, primarily in comparison to the EU. The EU, or the European Union, embraces the precautionary principle in much of its legislation. The precautionary principle suggests that people should prove things are safe. In other words, if a brand comes up with a new product, it's up to that brand to prove that its product is safe before it's legally available to be sold. The US, however, does not embrace this precautionary principle. Instead, US law suggests that consumers should prove something isn't safe before it's illegal for a product or service to be sold, or for practices online, such as data collection, to no longer be considered legal. So you can see how these legal differences in philosophy, in other words, prove it's safe versus prove it isn't safe, can have some very big effects on online privacy and online privacy law. As a result, what I've noticed in my career as a digital marketer is that we'll often see the biggest changes in law occur in EU first, and often some of those changes will actually trickle down to the US later. One such example is what you're looking at on this screen right now, which is known as GDPR, or the General Data Protection Regulation. And this became effective in May of a couple years ago, 2018. I need you to understand that GDPR is the single most significant regulation of our industry of digital advertising ever. This particular statement is not disputed by any digital marketers. As I've suggested, sometimes it takes the US a little while to adopt some of these similar principles. So the US's response was actually signed in June of 2018. However, the response was not at the federal level, meaning it didn't concern laws that were applicable to all of our states. Instead, only California responded. And the legislation that was signed in June of 2018 was proposed for 2020. This law was called the California Consumer Privacy Act. Interestingly, when you compare the differences between both sets of laws, there's some pretty shocking differences. The GDPR, which is in the EU, suggests that consumers online have 8 basic rights: the right to be informed, the right of access, of rectification, the right to erasure to have our data removed online, the right to restrict processing, the right to data portability, the right to object, and rights in relation to automated individual decision-making, including profiling. For the right to access personal data, that suggests that a person has the right to access their own data held by any company. The third right, or the right of rectification, suggests that a person has a right to request the correction of their personal data held by a company or an organization. Number 4, the right to erasure or to be forgotten is a particularly important right. This right suggests that a person has the right in certain circumstances to request the deletion of their personal data when there is no compelling reason for its continued processing. In other words, when it doesn't make sense for a company to keep it. Number 5, the right to restrict processing means a person has the right to block or suppress the processing of their personal data. The right to data portability suggests that a person has the right to obtain personal data in a format to allow them to transfer that data from one organization to another. Another big one is number 8, the right in relation to individual decision-making, including profiling. And this particular right says a person has the right to object to automated decisions, in other words, decisions that may be powered through AI, based upon the processing of their personal data. This right also suggests that a person can request human involvement. This right is particularly interesting, especially in the world of AI controversy, where information about bank loans or employment is being automated through AI. You can see how some vulnerable populations may object to this. You can see the US's version, which is only suggested for California, the CCPA, only grants 5 rights. That's the right to disclosure, the right to deletion, the right to access, to opt out, and the right to non-discrimination. However, take a look at the penalties for violating any of these rights. In the EU, the penalty is pretty severe at 20 million euros. However, if a business or organization is found negligent in the US, a violation of these rights can lead to a $2,500 penalty. If an organization or business is intentionally trying to violate rights, the fine will go up to $7,500. But it's a far cry from the EU penalty, as you can see. The suggestions that lawmakers in the UK made during that time in 2019 may surprise you. Specifically, they suggested turning off what they call nudge techniques. Their laws suggested removing these nudge techniques, in other words, likes, especially on social media. Lawmakers in the UK suggested that this particular proposals would especially enhance children's privacy. More recently, the EU reduced, as of this year, a proposal for online regulation as it pertains to AI. Remember, I suggested that the EU will usually have stricter regulation concerning what businesses and organizations can do online. True to form, they unveiled, as of this month, strict regulations to govern the use of AI, a first-of-its-kind policy that outlines how companies and governments can use a technology like AI, seen as one of the most significant but ethically fraught scientific breakthroughs in recent memory. This proposal would set limits around the use of artificial intelligence in a range of activities, from everything including self-driving cars to hiring decisions, bank lending, school enrollment selections, and the scoring of exams. It would also cover the use of AI by law enforcement and court systems, areas that are considered high risk because they could threaten people's safety or fundamental rights. In this proposal, they say specifically that the use of AI with its specific characteristics, for example, opacity, complexity, dependency on data, autonomous behavior, all these characteristics can adversely affect a number of fundamental rights enshrined in the EU Charter of Fundamental Rights. So this presents you with an extra credit opportunity. If you can email me the name of any of the fundamental rights described in this particular legislation, you'll get extra credit. You can see, based on all of these laws and how data has or has not been used by organizations and companies online, there's been a wide variety of consumer responses. Many of them will outright refuse to provide their information, even something as innocuous as an email address. They'll often unsubscribe from email distribution lists. Many of them will ask for their information not to be shared. They may reject cookies or even give false information. There's a fun tool that I wanted to share with you called Terms of Service Didn't Read. This is an online tool described as a user rights initiative, and the website's designed to rate and label other website terms and privacy policies. Their ratings range from very good, Class A, to very bad, Class E. As most of us understand, terms of service, especially as they relate to online privacy, are often much too long and cumbersome to read. But it's very important for us as consumers to understand what's in these terms. Indeed, your rights online depend on them. So this version of Too Long Didn't Read hopes that their ratings can help consumers get more informed about their rights. You can see that they've actually rated Facebook as a Class E. Alternatively, they've rated Google as a Class C. And you can compare the differences based on each brand's terms of service. Another way that you as a consumer can protect yourself is, of course, to enable or disable cookies. Here's a quick screenshot from Google to show you how to do this. And again, on Google, you can always edit or delete your Chrome browsing history. Naturally, in this discussion, another consumer concern that pops up is that of identity theft. That's because our personally identifiable information, or PII information, can often be discovered online. PII is any data that could potentially be used to identify a particular person. Examples include your full name, social security number, a driver's license number, a bank account number, a passport number, or an email address. Related to this topic is another question I want to ask you. Based on the image on the screen, who would you suggest is this famous CEO? The man shown on the screen is Evan Spiegel, who's still the current CEO of Snapchat. He's pretty famous for saying that he thinks targeted ads are very creepy. You might find this interesting as marketing students because this is the stance the CEO of a relatively newer social media platform had from the very beginning. However, if you know the business side of Snapchat, you know that this stance is not held company-wide. Indeed, there's lots of specific targeting through advertising on Snapchat that brands can engage in. There are 3 ad targeting options for brands: the Snap Audience Match, Lookalikes, and the Snapchat Lifestyle categories. As you can see on the screen, businesses can target Snapchat users by age, gender, their location, their device, the operating system, interests, first-party audiences, lookalikes, and purchase intention. You as marketers have used ad targeting yourselves, especially as it concerns Google Ads. What we haven't discussed at length are potential ethical implications. One of the implications is when marketers or brands use classical conditioning in their ads to send a very specific message to recipients. One organization that's gotten a lot of press for using this very trick is called The Spinner. The Spinner is a service that enables people to subconsciously influence a specific person by controlling the content on the websites that he or she usually visits. The targeted person gets repetitively exposed to hundreds of items, which are placed in disguise as editorial content or native advertising. The person who purchases this service selects the message that they wish to deliver to that specific person. The targeted person is exposed to 10 articles on major social networks and news sites over a 3-month period. You can watch their ad here, but remember this as an example of what not to do in marketing.
The Spinner is a new online service that enables one to control articles presented to a pre-chosen specific individual on the websites he or she usually visits in order to subconsciously seed a message in their minds. That person, the target, is exposed to hundreds of items strategically placed as editorial content, repeating the same message over and over and over again. Whether it is propose marriage, quit smoking, initiate sex, or stop riding motorcycles. How does it work? The basic package offers a set of 10 different articles presented to the target 180 times over a 3-month period. The articles, along with their eye-catching headlines, are chosen by a group of psychologists in order to influence the target on a subconscious level. The Spinner sends you an innocent-looking link. The link is sent to the target via text message. When the target presses the link, a cookie connected to the link attaches itself to the target's phone. From this point, the target will be strategically bombarded with articles and media specified for him or her. The story of The Spinner was covered by Rolling Stone, Financial Times, New York Post, The Sun, and many others. Alongside popular preset campaigns, The Spinner also offers tailor-made campaigns. The most requested tailor-made campaign is Settle Outside of Court, which has now been added as a preset campaign, and Get Back with Your Ex. If you're interested in a campaign tailor-made for your specific messages and goals, go to www.thespinner.net.
Other laws here in the U.S. that you as a marketer should be aware of as it relates to our restrictions online include COPPA, which is the Children's Online Privacy Protection Act of '98. This is an act designed specifically to help teens and younger consumers, especially those who are now online and have profiles of their own. The Gramm-Leach-Bliley Act and HIPAA are 2 other related laws that may restrict what you can do depending on the industry you serve as a digital marketer. One vulnerable group that you as marketers should be sensitive to includes children. Today, children have an incredible opportunity to learn, create, and communicate through the use of technology, often online. As a result, it's important that parents and other stakeholders are confident in children's understanding of digital devices, apps, games, and their ability to ensure a positive experience online. The Family Online Safety Institute, otherwise known as FOSI, has recognized this need and created a How to Be a Good Digital Parent toolkit. This is a toolkit specifically designed with parents in mind, but may be very appropriate for even brands to consider, especially brands who serve minors. I especially encourage marketers to consider toolkits like the one provided by FOSI because of the sharenting phenomenon that's occurring, especially as a response to the pandemic. Think about all the PII information that's now online about these vulnerable consumers. Another ethical consideration for marketers is that of domain name registration, which has led to the phenomenon known as cybersquatting. The example shown on the screen illustrates this concept of cybersquatting. Cybersquatting is registering, selling, or using a domain name with the intent of profiting from the goodwill of someone else's trademark, and cybersquatting may be illegal according to the Anti-Cybersquatting Consumer Protection Act. On the left is Grubhub's shadow page that links to a small business's Grubhub site. On the right is that small business's real website, which processes orders using a completely different system. In this case, Grubhub is found guilty of cybersquatting. If you were the small business, where do you think you'd want your consumers to go first? Through the website on the left, which looks like the small business's website but isn't. It actually redirects consumers to Grubhub. Or would you rather want them to go to your own website, the one shown on the right? Ultimately, marketers should engage in what's called the Fair Information Practices Principles, which is notice, consent, access, security, and enforcement. The principle of notice means that brands should be transparent and make sure privacy policies provide meaningful notice about data collection and use. Brands shouldn't make promises they aren't keeping. For example, the FTC prosecuted Snapchat on the basis of the company's privacy notices and other statements, which claimed that user messages would disappear after a set period of time. In reality, the messages were stored in Snapchat's logs and can be accessed by third-party apps, so Snapchat got in a lot of trouble for that. Consent is a principle that's also known as choice and control. Getting the consumer's consent for data collection and use is a must, including getting express consent for the collection of sensitive data. Access is a principle that provides a way to alter or even possibly delete the data that brands hold about their consumers. Security is a principle related to securing all valuable personal data about our consumers. Brands should have the right organizational and technical measures to prevent unauthorized access or disclosure. The FTC has brought actions against Credit Karma and Fandango for misrepresenting security practices and failing to secure consumers' sensitive personal information. Enforcement includes both government regulation as well as self- and co-regulatory frameworks. Also, it's important for brands not to misrepresent or misstate a membership in a regulatory framework or safe harbor. This point was made most recently by the FTC, which just finalized 2 actions against companies for misstating their EU and US safe harbor participation status. The image shown on the screen now shows you kind of at a glance and globally a variety of privacy protection restrictions. You can see countries in orange have minimal restrictions. Countries in blue have the most restrictions. Lastly, let's cover some technical issues that may affect us as digital marketers or may affect our consumers. The example shown on the screen illustrates phishing. And phishing usually concerns emails. So a brand engaged in a lot of email marketing might be particularly sensitive to this particular risk. Phishing is specifically about emails attempting to collect a person's personal identifiable information, or PII. Farming is also illustrated on this image shown on the screen. These are sites or pages that are meant to look like a valid website. Fortunately, many savvy consumers can recognize farming attempts by the URL. In the example circled in red, you can see the PayPal site on the right, which is legitimate, and the one on the left, which is not. Spoofing is another risk. These are emails sent from someone pretending to be someone else. Spoofing may take place in a number of ways. Common to all of them is the actual sender's name and the origin of the message, which are concealed or masked from the recipient. Finally, let's end the chapter with a discussion on copyright versus Creative Commons. As I mentioned, intellectual property is a big deal for brands, especially online, as it concerns their digital assets. One mistake I see young marketers make a lot is finding images online that are protected by copyright. In other words, it's the artwork or imagery that belongs to someone else. As a result, it was important for me to make sure that you knew as a marketer online that the Creative Commons exists specifically for this reason. The Creative Commons is a nonprofit where a person or a company still has copyright to their work, but they can choose conditions under which people or brands can use and distribute their content without explicit permission. Creative Commons helps you legally share your knowledge and creativity to build a more equitable, accessible, and innovative world. They say specifically that the site unlocks the full potential of the internet to drive a new era of development, growth, and productivity. So if you're in need of digital assets, I would strongly suggest the use of Creative Commons versus alternative sites like images.google.com.